The final matter to come before the court this morning is Bradley Scott versus City of Elyria et.No. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant in this case and wish to reserve any time, if you let me know when we get started, I'm keeping the clock this morning and we'll be apprised of the passage of time. We have read the briefs and we're ready to see them on.
Good afternoon. I am Margaret O'Brien and I represent the appellant, the City of Elyria. I would like to reserve 3 minutes for rebuttal. May it please the court. What was Bradley Scott doing at the precise moment of his death? Was he working for his employer as a police officer or was he on a personal errand? That is the issue that's before you today. The evidence is overwhelming. At the precise moment of Bradley Scott's death, he was on a personal errand. He was riding his personal motorcycle to his personal residence. He was not within the course and scope of his employment as a police officer at the time of his death. The employer did not receive any benefit from Bradley Scott returning his motorcycle home to his residence. This case is before you because the trial court granted appellee's motion for summary judgment. This court must conduct a de novo review of this case. Based upon the summary judgment standards, there's no issue of genuine fact. In fact, both parties in this case, and I think counsel will agree with me, is we have all agreed on what happened here, what the facts were. When we went into common pleas court, there was not a trial. It was all done in summary judgment motions because we believe this is a question of law. We know what happened to Bradley Scott and how he died. The City of Elyria is entitled to judgment as a matter of law. Fribo versus Visiting Nurse Association of Mid-Ohio, the case that the court asked us to brief, the Ohio Supreme Court held that the dual intent doctrine is not recognized for purposes of analyzing a workers' compensation claim. Instead, the Supreme Court held that the injury should be examined pursuant to the standards of every workers' compensation claim. Did it arise out of, was it in the course of his employment? Fribo involved a visiting nurse who was on her way to visit a patient, and she also had her children and their friends in her car. She was going to drop them off at the mall, and then she was going to go on and do her patient visit. She was involved in a traffic accident before that occurred. That was also a case based on a motion of summary judgment, and the Ohio Supreme Court said that there were genuine issues of fact because Fribo was a fixed situs employee and the issue of personal errand. However, in this case, what you have is an agreement on the facts. Bradley Scott was on union leave. He was at a union-sponsored steak fry. He was working to set it up. At the time he was working at the steak fry, there was another police officer off duty who was at the steak fry. And Bradley Scott says to this other police officer, "Hey, I rode my bike in today. It's going to rain. I need to take it home." She agrees. He said, "Follow me in your car after we drop off the bike. You know, we're going to get something to eat, and then we're going to stop and get something that's munchies for the steak fry." That was their intent. So what this
well, you said there's no dispute as to the facts, but that's not how it was presented on the other side, right?
No, I think that is how it's presented.
I think, wasn't it presented that, well, maybe it's just the order of things, okay, that he did want to get some more munchies for the steak fry.
Yes.
That was the whole purpose of going out, but then it started, it was going to rain and they needed food. So I guess it's all just how you present it, and so that's what I was getting is, are there really issues of fact in this at all?
No, I don't believe in it, and we'll see what counsel says about this, but I think we've agreed upon how his accident occurred. That he was on his way home to his personal residence at the time the accident occurred. The accident didn't occur after he went home and got in the other vehicle and was getting munchies. The accident occurred before he got to his personal residence. The testimony from the police officer that was following behind him, which is included in the transcripts and in the motions, clearly indicates that's what the plan was to get the motorcycle home because of rain, stop and get something to eat, and get some munchies along the way. The munchies, going back, I think, to the officers and the parties that there at the steak fry to give to them as they're preparing for the steak fry. So the facts about the two cases are very, very different. I think what's really important is the Ohio Supreme Court says, look, it doesn't matter whether the nurse was going to pick up, visit a resident or drop off her children. She may have had two reasons why she was doing something, and Bradley Scott may have had two reasons why he was doing something. He wanted to take his motorcycle home, and he wanted to get something to eat, and he wanted to get munchies for the steak fry. So maybe he had three reasons why he got on his motorcycle. The important thing for this court to analyze, what really matters, and what the Supreme Court says matters, is what was he doing at the time of the accident?
And we were talking about this before we came out. It gets confusing when we have to have these cases re-argued and everything, obviously. But I have in my notes, since I was one of the panel members that was on the original case, that all parties have agreed that the dual-purpose test and the Frival case has no bearing on this decision and is right for adjudication. So I'm not sure why we're arguing the Frival case.
I think we're arguing the Frival case because I think what the Frival case says is that, yes, I agree. I'm sorry, maybe I didn't hear all of what you said.
Well, I'm just saying because we had originally, before one of our judges, maybe reassigned after that, we had asked the parties if they would address, since a new Supreme Court case had come out during the pendency of our review, the Frival case. And I just have in my notes that all parties agreed that the dual-purpose test played no role in the matter before the trial court until the fight for determination of the patient well-established case test cited herein, the Frival really wasn't relevant.
What the Frival case is relevant for is, I would agree that dual intention is not relevant. The Ohio Supreme Court said that. That was the holding of the case, is that wasn't a way to analyze the workers' compensation case. What they said was, and what I think the parties agree upon, is the case has to be analyzed as a workers' compensation case. Was he in the course of his employment at the time of his injury? I think that is the issue that's before you. So I guess as far as Frival goes, what I'm saying is dual intent doesn't matter. So whatever his intentions were, what was he doing? What was he doing at the time of his accident? And I think the answer to that is that he was on a personal errand. He was taking his personal motorcycle to his personal residence at the time the injury occurred. That's what was happening. So even if you were to say that his attending a union function was somehow related to his work and he was at work, quote unquote, or doing something for the employer, quote unquote, at the union function, when he made the decision to take his motorcycle home, it wouldn't have been any different if he had ridden his motorcycle to work, got in a uniform, got in a police cruiser, and then sometime throughout the day in his shift, he says, look, it's going to rain. Oh my gosh, I rode my bike here. I want to take it back because I don't want to be riding in the rain. So maybe he does it on his lunch break, maybe he does it on a break, but he decides that he's going to ride the personal motorcycle home and somebody's following behind him, but he wouldn't be doing duties for the purposes of his employment. He would be running a personal errand. He would be taking his motorcycle to his personal house, which is what he was doing that day.
What if on his way back he was going to pick up something from the chief?
I think that goes to the dual intention argument that Frival says, and the Supreme Court says, that it doesn't matter if on the way back he was going to do some munchies.
Then if the court below didn't consider that dual purpose in the Frival case, then what should we remand it for them to look at the first time?
It was sent back down, I believe, for the court to look at the issue of whether or not she was on a personal errand.
No, I'm talking about the Frival case.
I
don't know. It's getting very confusing because this case has been around for a long time. But I thought that we had not remanded it because all the parties had said it didn't matter. Because that was an issue. But go ahead. I'm sorry. We'll take a look at it.
I'm sorry if I'm being confusing. Hopefully I'm not doing that. I think the issue is, what is the dual intentions? What was she doing at the time, or he was doing? And I think the Frival case was remanded back down by the Ohio Supreme Court to the...
Well, I'm not talking about the Frival case. I'm talking about this case.
Okay.
That's where the confusion is coming, and I apologize.
All right.
So, in the course of arising out of his employment, is the city conceding that this union steak fry was in the course of arising out of his employment?
No, the city is not conceding that.
But the city arguing that that's not relevant?
I don't think the city's not arguing that it's not relevant, because certainly he was doing that, and so it is relevant, whatever he was doing before this occurred. But I think what the city is arguing to you, and I think what is the most relevant point here, is what was he doing when he was tragically struck and killed? That's really what's before you. Anytime you have a workers' compensation case and a person decides they want to do a personal errand, maybe they were at work and they decide they need to make a bank. They want to go to the bank. So they leave work and they walk across the street to go to the bank, and they're hit on the way they're walking across the street. That's not something they're doing in the course and scope of their employment. Traveling for a police officer, if he were traveling into the police department in the morning to go to work on his motorcycle and he were hit, it would not be a workers' compensation claim. Even if he got into work and he was on his shift and he decided that he wanted to take his motorcycle home because he didn't want to drive in the rain, and he's on his way home and is hit, then again, it's not a workers' compensation claim. I think one of the questions was, well, what if he had gone home, got maybe in the other car with the other police officer, and now they're on their way to get munchies? Is there an argument that somehow that's related to his work for the union and maybe the employer is involved in that? Maybe, but that's not what's before you.
So if we follow your analysis, then it sounds as if the course and scope is determined purely by the order in which the individual decides to run certain errands. So he could have said, okay, I have to do A, B, and C. And purely on the basis of the order in which he decides to do, say, B instead of A first, would determine whether he was within the course and scope. That seems a little irrational to have a court decide as a matter of law whether or not he's in the course and scope. Doesn't it to you?
Well, I think when you look at the arising out of prong, and you look at the elements for course and scope, proximity of the scene of the accident to the place of employment. Well, in this case, he's on a public highway with everybody else who's driving on a public highway. So clearly the employer doesn't have any control other than it's in the city of Elyria. Degree of control the employer had over the scene of the accident. Again, the employer had no control over the scene of the accident. Had the employer instructed him to go home and take his bike home and he was tragically killed, that's a different situation. This was a decision he made, a personal decision. He didn't ask anybody from the police department, can I take my motorcycle home, it's going to rain. It was a decision he made, and at that time on his own. The employer did not direct that. And then, of course, the benefit the employer received for the employee's presence at the scene of the accident. Again, I don't think that that's the issue that's before the court.
Well, let's change the facts just a little bit to say that his motorcycle is not a part of this. He's in the vehicle with his other colleague who is driving, and they have two things that they need to do. One of them is to stop to get snacks. The other one is to take him home to pick up his checkbook, which is
personal.
He doesn't have control over which one is done first, but she decides to drive to his home. Are we to then make a decision regarding whether the accident took place arising out of the duties of his employment based on a decision that the driver made to go to B first rather than A?
Okay, I think this is that is a distinction that we don't have here.
Now, I understand that, but I'm saying that if we follow your analysis, it could very well turn on that.
Well, I believe what the Supreme Court has said is the employee's subjective intent is not determinative. That does not determine whether there's a workers' compensation claim. So their intent isn't determinative. What is determinative is did it occur in the course of and arising out of their employment. And I think when you look at the elements that are required to show that something occurred in the course of employment, it's not here because he was on a personal errand. Now, if that personal errand would continue on to some employment-related issue, and that occurred, that's a different situation. It's not what you have here, and the city is not conceding in any way that his attendance at the Union Steak Fry that was sponsored by the union was city employment, or that the city is responsible in that regard.
You're reaching into your 3 minutes of rebuttal time. You may proceed or reserve.
acted on this week. Thank you.
May it please the court, my name is David Briggs, and I'm the attorney for the appellee who's the widow claimant and the 2 minor children of the deceased police officer. Allow me to begin by indicating to you, when I make my Court of Appeals arguments on workers' compensation claims, and I primarily do workers' compensation work as my profession, I always leave it to the end, and I never think I'm going to use up all 15 minutes, and so I never get to it. But at the outset, I just want you to be aware, and I know that you are, and it's in my brief, and it's conceded to actually by my opponent that indicates that the workers' compensation statute, and I think you know what I'm going to say, it's to be construed, and she concedes, to be construed in favor of the injured worker. But what, respectfully, and I like Ms. O'Brien a lot, I've seen her in many cases, what she didn't indicate to you in her brief was that that statute requires that the workers' compensation statutes, all of them, be liberally construed in favor of the injured worker. I'm not relying totally on that. I think my case is solid as can be, but I just want you to keep that in mind as you discuss the case amongst yourselves, as you listen to my argument and you listen to Ms. O'Brien's rebuttal argument. With that being said, the next thing I want to cover, because I'm trying to do this in a cogent way, when you're the appellee, you're sort of sitting or shooting at ducks that are moving. You're reacting to what was brought before you. You'd like to present your case in full in a cogent manner. But I don't have that opportunity, so I have to be able to respond to what she has said in the time that I have, and I don't have rebuttal. The Freibel case. Judge Carr, you're right. Freibel came out, I got the notice from the Court of Appeals saying, okay, look at this decision. I'm like, oh my God, now what happened? You know, here we go again. We've been dealing with this since August of 2004 when he died. The opinion is sent. Typical me, I'm a naysayer, oh my God, it's going to kill me. And I start reading the case. It's like, But I got into it, and I read it 3 and 4 and 5 times, and I'm like, well, wait a minute. This doesn't have anything to do with my argument. As the appellee, I have always argued in my motion for summary judgment, in my brief to the Court of Appeals, in the oral arguments that we gave before back in March of 2014. The analysis focuses on those cases and the elements that are proposed, the time, the place of injury, the circumstances of injury for the one prong, the proximity of the accident site to the employment site, the degree of control that the employer has over the accident site, not the activities of the injured worker, and whether or not there's a benefit to the employer, if it inures to the employer for that employee to be at the site of the accident. So Freibel, in essence, doesn't change that. If you look at the wording, they say that just because there's a personal element to a work travel or work trip, it's not fatal to the workers' compensation claim. What they say is, look at the total analysis that we've always espoused. When I say this, I'm not being disrespectful to a Court of Appeal, but I think what the Supreme Court is saying to the Richland County Court of Appeals is, hey, wait a minute. Never have we espoused a doctrine, a dual intent, dual purpose doctrine to cover every case. The Supreme Court is saying that every workers' compensation claim, because of the nature of the injuries, is fact-specific. And the Supreme Court has always resisted a one-size-fits-all, one test only, a hard, fast, rigid approach to analyzing these cases. And so what the Supreme Court case was saying is, you're not going to force this dual-purpose, dual-intent doctrine on us, Richland County Court of Appeals. We've never subscribed to that, and we're not about to now. Do the complete analysis as is required in the Ruckman case, the Lloyd case, and the case that I love that pertains to this factual situation, the Fisher case, the Flower Farm case. And so that's why when Judge Carr indicated it doesn't impact it. It still requires the analysis that's always been required by the Supreme Court. They hate hard and fast rules, hard and fast tests, and the reason they said that is because it can result in unfair decisions. And that's why that was done. If I can, and respectfully to Ms. O'Brien, she keeps portraying the facts of this to indicate that he was on a purely personal mission It's not accurate. She then sort of refers to, oh, but also, you know, they were going to pick up munchies, so that's the work-related part. In the brief that I provided with respect to the Freibel decision later on, I said the going for munchies or snacks is important insofar as it brings it back within the purview of workers' compensation coverage. It has a nexus, a work connectedness between where he was and his employment.
But if you look at, to her credit, if you look at the factors, you know, the proximity to the workplace, etc., surely the fact that he was riding his own personal motorcycle going to his home is something to be considered, and it's not necessarily in your client's favor.
I'm glad that you asked that, and I don't say that flippantly. Every single decision has always talked about that these elements, the degree of control, the proximity, the benefit, those are guidelines. You don't have to have every single one of those. Look at the Fisher case. She was not on school, she was not at her school, she was not on the clock, she was at a different locale. The Cooper versus City of Dayton was a police officer who was moonlighting as a security guard at the place, at Groceryland, the grocery store. He's not on the property of the City of Dayton. He wasn't on the clock, he wasn't being paid by the City of Dayton, he was being paid by the grocery store. So that's a similar case where workers' compensation benefits were afforded because they did a complete analysis. Every single case says you don't have to have every single one of these. It's a totality of the circumstances analysis. Simply because he was driving his personal motorcycle, it's not fatal to the claim. I understand what you're saying, but the case law does address that and says, no, you're not required to prove all 6 of these: time, place, circumstances of injury, degree of control, proximity, and benefit to the employer. You don't have to have all of those. Look at them all together in concert.
Well, just speak then, would you, to the benefit to the employer?
Yes. Actually, there's all the recreational cases, and there's the Fisher case, the Flower Fund case. There is a benefit which inures. I think they talk about that there's a tangible, though immeasurable benefit which inures to an employer to have social activity, to have company picnics, to have basketball games that you sponsor the team or whatever. And case after case, Kohlmeyer is the one that comes to mind. Columbia Gas was the basketball one. Kohlmeyer was the company picnic where the guy was diving into a pool and sustained an injury that way. All of those have said, yes, there is a benefit to the employer. This camaraderie, this working together. I think now it's called team building, where the corporate world sends people out to these team building missions. It's important because there is a tangible, though immeasurable benefit to the employer to have social activity. All of the recreational cases talk about that.
To that end, even though you may not need to set all of the factors when we're trying to make a decision, is in the course of and rising out of, both need to be satisfied for coverage? Are those 2 sides of the same coin? No,
they both can be taken in conjunction, but all of the elements of one can be missing, but there can be some elements of the other prong which can be there. I think it was Fisher that says, look at them in the conjunctive instead of a bifurcated approach. I think it was either the Fisher or Lord case that says you look at them in conjunction. You don't have to bifurcate them and look to see if, okay, we've got one from here and one from here, so we're good. If they're all missing from here, but you got 2 or 1 over here, that's still okay.
That sounds like it's looking at the 2 in the disjunctive way. Either rising out of or in the course of employment means that there's coverage versus in order for there to be coverage, it has to be in the course of and arising out of.
Yes, and I think that's actually contained in 4123.901 of the revised code that defines what a compensable injury is, and it uses the conjunctive. And I do believe it was the Fisher case who says you have to look at these in the conjunctive. But starting on page 20 of my brief, I set forth how the facts of this particular case affect the time, the place of injury, the circumstances of injury, and then the other degree of control, proximity, and benefit to the employer. I think of the 6, the weakest one, there's 2 that are missing. I mean, I'm not saying that the degree of control over the place of the accident in my particular case is covered, although in the case Cooper versus City of Dayton, They're saying that that police officer who was moonlighting as a security guard began to effect an arrest, and therefore he transitioned from being a security guard to a police officer, and therefore the proper employer is the city of Dayton. I think they made mention of the fact that the entire city of Dayton is their work site, so to speak. I don't know, I think it stretches it a bit, to be honest, but it does support my position. Here I am arguing, well, I think it's still a little weak, even though a court said it, and I'm shooting myself in the foot by saying it. But I certainly think that the benefit to the employer is very, very strong in light of all those recreational cases and in light of the Fisher case that I keep calling the Flower Fund case.
So he's on union leave.
Right.
And let's say instead of going to the local picnic, he is on his way down to Washington, D.C. for something regarding law enforcement, memorial service, something of that nature. But he's allowed to do that under his union contract. But he's on his way down there. And I think you could reasonably argue that attendance or participation in something of that nature may give some benefit to the city. He has a motorcycle accident on his way down to one of these services, and he's on union leave. Is he covered by workers' compensation?
Not to be haughty or arrogant, but absolutely yes. In this particular case, the city had to approve the union leave. What's interesting in this case is he has to go to a supervisor and said, I need union leave and this is the purpose. And in this particular case he did, and he was granted 8 hours. I was shocked, and it's in my brief, where the city then took away, because he only lived 2.5 hours into his shift, that they took away, 5.5 hours. That goes to show the degree of control. Let's say the city, or the brass said, you know what, this union snake roast, which incidentally was a long-standing practice, approved by the city for many years, as was the Flower Fund, tacitly approved by the school board for 9 years. But with respect to the approval of the time, if they had said, no, you know, that's too far-fetched, that's not in keeping, we're not going to approve that. And they had the right to do that. We know that because they took away hours, the city.
Did they were almost, I guess my understanding was, this was permitted pursuant to the parties' collective bargaining agreement with respect to what they can and cannot approve and pay union leave.
That's right.
Which doesn't speak to whether or not it's in the course of his employment.
Right. I think what we're talking about is it's a union. She keeps arguing that, well, this isn't work-related because it's union-sponsored. It has nothing to do with work. But what do we have from Chief Metters, both testifying at the administrative hearing and by letter, I think dated March of 2006, indicating he's on city time. And so being on city time lends to it the city's approval of this. Anything that occurs during that time is work-related. She wants to, I don't mean to say she, Ms. O'Brien wants to liken this to sick time or vacation time, but it's like court time. Police officers they get an additional pay when they go to court. So if they're hurt on their way to court, or they fall down an elevator shaft at the Justice Center or whatever it might be, you know, they're on court time. They're on city time, they're not on duty. She keeps trying to make that distinction between being on duty and...
Well, I mean, court time is part of their official duties, correct? They filed an affidavit in their case, they made some allegations, and they have to go to court.
Oh, absolutely, but so is union time, because that is negotiated between the city and the Elyria Police Patrolmen's Association. She keeps talking about, well, this is union-sponsored or union-supervised. Keep in mind that an employer doesn't have to supervise or sponsor something for the injury to be determined to be work-related. Look at the Flowerscape. At first they said the company picnic, Colmeyer, okay, it's union-sponsored, it's paid for, sponsored, and supervised by the employer. It was just company people. Guy hurts himself diving into a pool. Okay. Then they move away from it with the Columbia Gas. The employer isn't supervising this basketball league, but they're sponsoring a team, the Columbia Gas basketball team, and he's hurt. And then we've got Flowers. It's an evolution away. Flowers, it's not supervised by the employer. It's not sponsored by the employer. They know about it and they allow it to go on. So we have nothing about supervision or sponsoring, but yet still it's found to be an injury that occurred in the course and scope of employment and arose out of employment. I think the magic words, and you've seen it in my brief, is the CBEC case. And in CBEC, what they're saying is that so long as the injured worker is engaged in a pursuit or undertaking with his contracted hire, and which in some logical manner pertains to or was incidental to his employment, then the death occurred in the course and scope of and arose out of his employment. So it's there right before us. If I can, I want to clarify something about the, whether there's a genuine issue of fact. We have agreed that it was a trifold mission. Initially, respectfully, and then she came around. She keeps telling you that this is to put his personal motorcycle away. It's hard to sit there and say, no, it's not just about that. And then later on, she feeds you the fact that they were going to get a bite to eat and that they were going to put his personal motorcycle away because of a threatening storm or whatever. It was never clear from the only detective who was with him, Detective Lisa Dici. She just testified that these were the reasons we were leaving. There was no clarity to the order in which they were to be done. She simply said it was an unfinished conversation. You just don't expect that the person's going to die. That was her testimony.
And counsel, regretfully, I need to inform you that you've reached the end of the
I guess I always do use up my 15 minutes.
And equally regretfully, you have about a little over a minute left.
Oh, I thought you had 3 minutes.
You reserved time for rebuttal, but you had gone into that, so.
Okay, I'll make this super quick. Young versus State Highway Patrol Department Administration, 20th District Court of Appeals case that clearly is relevant in this matter. That case says you need to look at the course and scope of employment. It was about a trooper who was doing the basketball. I'll let you read it since I don't have that much time. To speak to what counsel had to say, and I'm not going to refer to him as he throughout my argument, it is completely different than a court case. Officers are subpoenaed into court. It's part of their court duty. The burden is on the employee in this case, never the employer. I do agree that the guiding principles are construed in the favor of employee, but however, it has to be measured against what the Workers' Compensation Act is about.
Well, but you have to admit the employer is getting a benefit from this.
From him taking his motorcycle home?
No, from the steak fry itself.
If you want to say the employer's getting a benefit because the union's having a steak fry where the union, the employer cannot become involved in that union-sponsored steak fry. The employer can't sponsor it. They can't take any type of financial benefit from the steak fry.
But they can say you can't take union leave to cook at a steak fry or set it up. They can say that's just not a proper union leave. We're not going to approve it.
I think you need to take the union completely out of this. I think the whole thing, whether he was at a union-sponsored steak fry or whether he had been, like I said before, on duty and decided to take his motorcycle home, I don't think that's the issue. The issue is, was he within the course and scope of his employment? Would the employer, in any other situation where somebody's taking home their private motor vehicle, if you decided today on your lunch hour or your break or however else you wanted to, that you wanted to run a personal errand, to go to the bank, go take your car home, whatever your personal errand is at the time that that occurs, you're not within the course and scope of your employment.
And counsel, regretfully, you have also reached the main ending of your 15 minutes of allotted time. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website, which can be accessed through our website should you choose to do so. Thank you both for your presentations.
Thank you.
We are adjourned.